4 of your American government class. I am Mr. Dean. I'm glad that you are able to join me today, and we are going to start talking about the fun stuff, to me at least, and we're going to start with the concept of civil liberties. As always, I hope that you take notes as we will be diving into this. This lecture may be a longer lecture than normal, just because there is a lot. We will talk about the Bill of Rights and kind of go through the first 10 amendments. So get you some popcorn, do what you need to do, and let's start this journey. So when we talk about civil liberties, some people confuse that with civil rights. But civil liberties and civil rights are distinct concepts, even though we use them interchangeably. Civil liberties references the limitations of government power that are designed to protect your freedoms. And we're going to learn about all of those civil liberties and how the Bill of Rights was incorporated to protect those freedoms. However, when we talk about civil rights, we're talking about the constitutional guarantees that the government will treat people equally, regardless of whether they are to be a protected class such as race, gender, ethnic origin, or religion. So there's two different concepts. This week we will be talking about civil liberties. We will talk about civil rights next week, but we need to have a firm understanding of what civil liberties are so that we don't confuse the two concepts. So many of the most important civil liberties protected under the Constitution are contained in the Bill of Rights. So remember, the Bill of Rights was the first 10 amendments to the Constitution. Article 1, Section 9 of the Constitution also contains protection for civil liberties by prohibiting Congress from performing the following. There's no passage of bills of attainder, which is a law that punishes a convict or punishes a person of a crime without a trial. There's no ex post facto laws. An ex post facto law is a law that takes effect retroactively. So that would be putting a law in place starting January 1st, but making it retroactive to December 2020. The government can't do that. And then there's no suspension of a writ of habeas corpus. So a writ of habeas corpus requires an ex parte hearing by a neutral judge to determine whether a person has been unlawfully detained. So let's talk about the Bill of Rights. So remember I told you earlier that the Bill of Rights is the first 10 amendments to the U.S. Constitution. That is something you probably want to write down and probably want to highlight. However, your textbook does a really good job of this, of kind of putting it into perspective for you. There are three main categories to the Bill of Rights. There's the protection of individual freedoms. There's protections in regard to the criminal justice system. And then there's the residual powers and state powers. So remember that state powers were not expressly talked about in the Constitution. The Bill of Rights, the last portion of the Bill of Rights, is what kind of spells out some of those state powers. All right, so let's look at the Bill of Rights. Right now, you can see on your screen, I have the first 10 amendments to the Constitution, which is known as the Bill of Rights. We're going to go through these one by one. So I wanted to give you a bigger picture before we kind of dive in. So the Bill of Rights contains the following protections for civil liberties. And remember, whenever we go back to our introduction concepts, John Locke came up with the concept that we all have natural rights, and that's life, liberty, and property. So civil liberties really kind of dates back to the foundation of the Constitution. Remember, we've had that conversation. So your First Amendment is the right to freedoms of religion and speech, the right to assemble, and to petition the government for redress of grievances. And you don't have to write all of these down. You have the PowerPoints, and we're going to go through these one by one. So then you have the Second Amendment, which is the right to keep and bear arms. The Third Amendment is the right to not house soldiers during times of war. Fourth Amendment is the right to be secure from unreasonable searches and seizures. Fifth Amendment is the right in criminal cases, including due process and indictment by grand jury for capital crimes, as well as the right to not testify against oneself. Sixth Amendment is the right to a speedy trial by an impartial jury. Seventh Amendment is the right to a jury trial in civil cases. Eighth Amendment is the excessive bail and excessive fines, and the right to not face cruel or unusual punishment. The Ninth Amendment is all rights are retained by the people, even if those are not expressly enumerated in the Constitution. And the 10th Amendment is all powers not specifically delegated to the federal government or prohibited to the states are retained by the states. So whenever I say that the Bill of Rights really can be thought of in three separate categories, you have the first through really the first through fourth that really deal with individual freedoms. Then you have the fourth through the eighth that are dealing with liberty in the criminal justice system. And then you have the ninth and 10th that are dealing with residual powers and state powers. So that's just a really kind of easy way to think about, to break down the Bill of Rights, is to think of it in three sections. So before we dive into the Bill of Rights in depth, we need to talk about the concept of incorporation. And what I mean is states incorporating the Bill of Rights to help protect the civil liberties of the citizens. So in the early 19th century, the U.S. Supreme Court held that the Bill of Rights only applies to the actions of a federal government. So basically, early 19th century, the Supreme Court said that the Bill of Rights only applies to the actions of federal government. States did not. However, after the ratification of the 14th Amendment after the Civil War, the Supreme Court gradually expanded the protections of the Bill of Rights to cover state government actions through what we call incorporation. So really, after the 14th Amendment, you're seeing incorporation happening more and more at the state level. Incorporation relies on the Due Process Clause of the 14th Amendment, which is probably one of my favorite things to study, is due process, and that goes back to my criminal justice background. But the Due Process Clause basically says that the government cannot deprive a person of life, liberty, or property without due process. Does this sound familiar? Anybody? Does this sound familiar to? Yep. John Locke, our founder philosopher, who kind of gave us the foundation of our government. So it all ties back, and we have slowly seen that the Bill of Rights has been incorporated into all 50 states and the federal government. All right, so now let's start. Let's start diving in. So we're going to start right with the First Amendment. The First Amendment says Congress shall pass no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peacefully to assemble, and to petition the government for redress of grievances. Wow, what? That's a lot packed in there. So really, we're going to break down the First Amendment because there's a lot there. We're going to look at freedom of religion first, because as you can see, let me find my highlighter. So you see, the first part of this is make no law respecting an establishment of religion or prohibiting the free exercise thereof. All right, so that's the first part of the First Amendment. Then we also have abridging the freedom of speech. So there's your free speech. Then we have freedom of the press. And then we have the right of the people to peacefully assemble and the petition the government for redress of their grievances. So that is a lot packed into the First Amendment text. So let's break it down. All right, so the first part of the First Amendment that we're going to start with is the concept of separation of church and state. And with this, it basically means that the government cannot create a national religion. So remember when our founding fathers came over and established the colonies, they wanted to get away from the British rule and the concept of a national religion. And so it was important for them to have the freedom to express their religious beliefs that may differ from other people. So an important part of the First Amendment is known as the Establishment Clause. The Establishment Clause has gone back and forth throughout history, but today it tends to be interpreted a bit more broadly than in the past. It not only forbids the creation of a Church of the United States or a Church of Georgia, it also forbids the government from favoring one set of religious beliefs over the others, or over non-religious beliefs. So the government cannot have a national religion or a national favorite. While Christianity may be a popular religion, the government cannot impose Christianity as a religion onto its citizens, because that would go against the First Amendment and specifically the Establishment Clause. So when we talk about the Establishment Clause, you guys know I'm a sucker for the Supreme Court and for our precedents that are set forth. And there's an important case that you should probably familiarize yourself with, Lemon versus Kurtzman. And so the key question with the Establishment Clause was, should it be understood as imposing? So should a wall of separation between church and state exist, in the great words of Thomas Jefferson? So in 1971, Lemon versus Kurtzman, in that case, the Supreme Court established what was known as the Lemon test. And no, that is not a delicatessen. That is a test for deciding whether a law or other government action that might promote a particular religious practice should be allowed to stand. And in order to do that, they have a three-pronged approach, which you will see right here. So the Lemon test has three criteria that must be satisfied for such a law or action to be found constitutional and remain in effect. So as part of the Lemon test, The action or law must not lead to excessive government entanglement in religion. So, in other words, policing the boundary between government and religion should be relatively straightforward and not require extensive effort by the government. So it should be very straightforward that there's not governmental entanglement. The next part is, excuse me. So the next part is the law or action cannot either inhibit or advance religious practices. It has to be neutral when it comes to religion. And the act must have some secular purpose, which means that there's some non-religious justification for the law to stand. So your book gives a great, some great insight on this that you need to read to kind of better understand the lemon test. But the basis of it is the law has to pass these three prongs in order to remain in effect and basically say that the law is not a violation of the Establishment Clause. So the next clause that I want to talk about is the Free Exercise Clause. And the Free Exercise Clause basically prohibits the government from preventing or controlling religious practices. It limits the ability of the government to control those practices, and it regulates not. This portion of the First Amendment regulates not the government's promotion of religion, but rather the government's suppression of religious beliefs and practices. So with this, there is a couple of other interesting cases. So the first one is Sherbert v. Verner. And in this case, the court established the Sherbert test in order to limit or burden religious practices. So basically, with the Sherbert test, the government has to demonstrate both that it has a compelling governmental interest in limiting a practice and that the restriction was narrowly tailored. In other words, it must show that there was a very good reason for the law in question and that the law was the only feasible way of achieving the goal. So for the Sherbert test, when we look at the Free Exercise Clause, is a law that the government puts in place suppressing religious activities. There has to be a compelling governmental interest, and it has to be narrowly tailored. It can't be a law that encompasses a vast majority of things. Here's an interesting one that you don't have to memorize this. I just thought it was very interesting whenever I was reading through your book. So in Burwell versus Hobby Lobby, the government mandated private businesses to cover contraception under Obamacare. And basically what that meant was the government made private businesses offer Obamacare, and under Obamacare, they had to cover contraceptions. And Hobby Lobby's president took exception to this because, as we know, Hobby Lobby has deeply rooted Christian beliefs and values that they said that the government's mandate of this encroached on their First Amendment rights. So the Supreme Court agreed with Hobby Lobby's position and said that Hobby Lobby and other closely held businesses did not have to provide employees free access to emergency contraception or other birth control if doing so would violate the religious beliefs of the business owners. There was less restrictive ways the government could ensure access to these services for Hobby Lobby employees. So basically, private businesses' religious beliefs were covered under the First Amendment in this case and in precedent set forward. So that was just a really interesting case that kind of showed the free exercise clause in action. So you have the establishment clause, you have the free exercise clause, all under the separation. So going back to what we just talked about with the establishment clause, that clause has been controversial over a period of time, just because government officials acknowledge that we live in a society with vigorous religious practices, where more people believe in God than disapprove of God. Disputes have often rose up where the government acknowledges widespread religious beliefs. However, it's important to note, you see on our coinage, on any coin that you pull out, it will have "In God We Trust." The courts have generally allowed for a certain tolerance of what is described as ceremonial deism. And that is an acknowledgement of God or a creator that generally lacks any substantive religious content. So the motto "In God We Trust" appears on our coins and our paper money because it's seen as more of an acknowledgement that most citizens believe in God than any serious effort by the government to promote religious beliefs or practices. So that's also the same reason why you hear the phrase "under God" in the Pledge of Allegiance. Courts have allowed this just because it's not promoting Christianity. It's the courts have reasoned that it is basically the government acknowledging that the majority of its citizenry believes in a higher power. All right, so let's look at an example of the free exercise clause that we just talked about. So remember, the free exercise clause limits the ability of the government to control or restrict religious practices, right? So one of the most recent notorious cases related to the free exercise clause involves an Oregon bakery whose owner refused to bake wedding cakes for a lesbian couple in January 2013, citing that the owner's religious beliefs did not allow her to do this. The couple was eventually awarded $135,000 in damages as a result of the ongoing dispute. However, in similar cases, the U.S. Supreme Court has ruled in favor of the baker's rights. There's also a current case being heard this session of the Supreme Court that deals with the same free exercise clause, similar situation where I believe it's a wedding planner or the person who makes the invitations is basically saying that a Colorado law encroaches on her First Amendment rights under the free exercise clause because she has a religious objection to making any wedding invitations or anything like that for same-sex couples. So I'm recording this at the end of December, so the court has not released their ruling yet. However, if you've studied any of this over time, know that our Supreme Court is a lot more conservative now. I would fully expect that it would be very similar to the Masterpiece Cake Shop versus Colorado Civil Rights Commission, where they will rule that in favor of the graphic designer. All right. So now let's look at the second part of the First Amendment, which is freedom of expression. And freedom of expression refers to the rights protected under the First Amendment's free speech, free press, free assembly, and right to petition clauses. Speech, press, and assembly rights often overlap. So that is something that you want to keep in mind, is we're talking about expression. You don't necessarily have to agree with some of this expression that we're going to talk about, but we will talk about when does it cross the line of not being protected free speech, no matter how heinous it is. So the first part is the free speech clause. This clause prohibits the government from suppressing or restricting most forms of speech and symbolic speech. This term, symbolic speech, will be key in a little bit. So just keep that in mind. There's a case that the Supreme Court heard that kind of gave some gusto, I guess you would say, to the free speech clause, and that was Brandenburg versus Ohio. And it basically, in this case, the Supreme Court held that only speech or writing that called directly for or planned lawless action could be suppressed. So, under the Brandenburg standard, speech was protected unless it called directly for a lawless action. So next, we're going to talk about free press and the free press clause. We will discuss a lot of media information during week 7. However, it is important for you to understand that there is a free press clause under the First Amendment, and it prohibits the government from restricting the rights of the press to disseminate news and express opinions. There are some restrictions placed on the free press clause, which we will talk about. I believe it's a little bit later in this presentation. If it's not in this one, it will be in week 7. But again, there is New York versus Sullivan, where the court basically stated that in order to have the speech suppressed, the person who wrote the article had to prove that, or it had to be proven that the person who wrote the negative press knew that the information was untrue and had malicious intent to damage the person that they wrote the article about. So that's one of the restrictions, is the journalist or the news anchor, whatever, had to know that the information was false and purposefully project that information out into the world, knowing that it would harm someone. That is not protected under the free press clause. So the next clause is the free assembly clause, which prohibits the government from restricting peaceful assemblies. And then you have the right to petition clause, which permits individuals or groups to petition the government, including writing and calling elected officials, lobbying government officials, and filing lawsuits with the courts. So those are clauses that are protected under freedom of expression under the First Amendment. Flag burning. Flag burning is considered a form of expression speech. But is flag burning protected speech? All right, so we should know that the right to freedom of expression is not absolute. There are several key restrictions that limit our ability to speak or publish opinions under certain circumstances. We've seen that the Constitution protects most forms of offensive and unpopular expression, particularly political speech. However, incitement of a criminal act, which are fighting words and genuine threats, are not protected. So you can't point at someone in front of an angry crowd and shout, "Let's beat that guy up." Or you can't go to a senator's house with a mob and say, "Let's get that person." The Supreme Court has allowed laws that ban threatening symbolic speech, like burning the cross, like the KKK used to. And defamation of character, which, whether in written form, which is known as libel, or spoken form, which is known as slander, is not protected by the First Amendment. So people who are subject to false accusations can sue to recover damages, although criminal prosecutions of libel and slander are uncommon. Another key exception to the right to freedom of expression is obscenity, or acts of statements that are extremely offensive under current societal standards. So obscenity is a very gray area word. Like, what do we mean when we say obscenity? I found it quite funny that your textbook referenced Supreme Court Justice Potter Stewart. Whenever he talked about obscenity, he watched pornography inside the Supreme Court chambers and basically said, of obscenity, I knew it when I saw it. And while we know obscenity when we see obscenity, the courts have tried to narrow in a way to test to see if speech is obscene. And in doing that, they came up with the Miller test in Miller v. California in 1973. And according to the Miller test, in order to decide if something is obscene, it has to meet three categories. So whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the purest interest, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state laws, and whether the work taken as a whole lacks serious literary, artistic, political, and scientific value. Huh? So it's very important. Like, that's a lot of legal jumbo. What this basically means through the Miller test is that the concept of contemporary community standards means that something in Georgia could be seen as obscene that something in New York is not seen as obscene. It's a very real possibility. However, the one form of obscenity that has been banned almost without challenge is child pornography. That is one area that is universal. But we continue to kind of test the obscenity limits, and as you will see in our media chapter in week 7, we will kind of talk a little bit more about obscenity and kind of what restrictions are put on the media in terms of obscenity. So here is a picture of the KKK burning a cross in an African American family's front yard. We know that that is not protected speech and not protected freedom of expression. However, when we first started talking about the First Amendment, I brought up the flag burning concept, and I just wanted to kind of revisit that and tell you, yes, flag burning is protected speech under freedom of expression, and that was decided in Lawrence v. Texas. Your book has a highlight of that you should read should you be interested in that. But that is a protected form of speech as far as flag burning, but it does cross the line when it's threatening symbolic speech, like burning a cross in someone's front yard. All right, let's go to the Second Amendment. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It's worth noting that the Second Amendment is among the shortest but highly controversial amendments in our Constitution, out of the constitutional amendments. All right, in 2008, the Supreme Court found that an individual's right to bear arms for traditionally lawful purposes, such as self-defense within the home, falls within the Second Amendment rights. In that particular decision, the court applied to a law that was regulating the possession of firearms in the District of Columbia, or D.C., which is not a state, but a federal district that ultimately falls under the control of Congress. In 2012, the Supreme Court incorporated the individual right to bear arms into the Due Process Clause of the 14th Amendment, ruling that state laws regulating firearms could violate this constitutional right. So, while original interpretation of the Second Amendment was dealing with militias, we see that the Supreme Court has clarified the understanding and interpretation of the Second Amendment to protect an individual's right to keep and bear arms for traditionally lawful purposes. The next amendment is the Third Amendment, and the Third Amendment says no soldier shall in any time of peace be quartered in any house without consent of the owner, nor in a time of war, but in the manner to be prescribed by law. So basically what this does is prevents the federal government from coming and taking over your home and housing troops. The Third Amendment was important to the framers of the Constitution because of their experience with the Quartering Act, which required American colonists to house British troops in their home. So you can see at that time why they would want to have some protection for that. The Third Amendment has not been incorporated to the states because the U.S. Supreme Court has never considered this issue. This has never come up. However, the Third Amendment does have broader implications if you think about it. Yes, it's talking about the government can't come and seize your home to house troops, but it really is saying that your home is a zone of privacy that the government can't infringe upon. And so that's the broader implication of that. We will see. I couldn't fathom us ever needing the Third Amendment as far as being forced to house troops. You never know, but it would be interesting considering that the court has never considered that issue. So, all right, let's move on to the Fourth Amendment. The Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by an oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Whew, that's a lot. So we're going to break down the Fourth Amendment. All right, but the Fourth Amendment is the last part of the the protection for individual freedoms and starts talking about the protection for in the criminal justice system. This is where we start seeing that start to show up. So there are three main issues with the Fourth Amendment. You have search and seizure, you have warrants, and you have probable cause. So when we are talking about searching, we're talking about an effort to locate something. So if the police are searching for something, they are looking for something. If they seize it, that is physically taking something or things for use as evidence. So you have search and seizure, all right? This amendment says that you need a search warrant, which is a legal document signed by a judge allowing for the search and seizure. Now, I'm not going to get into the nitty gritty. There are some exceptions to the search warrant. I don't feel like we really need to go down that rabbit hole. If you're interested in that, you can kind of look more into the criminal justice realm. However, what you need to take away from this is that a search warrant needs to happen in 95% of the time in order for someone to come into your home, search your home or yourself, and seize anything. Now we're going to talk about probable cause. So whenever anyone goes before a judge and says, I need a search warrant to go search Adam's house, we think he has drugs in his house. Okay? So the judge is going to ask, what is your probable cause for this search warrant? And basically what probable cause is it's a legal standard. And it says that they have reasonable suspicion that a crime has occurred. So law enforcement would lay down all of their evidence of why they believe they have probable cause to obtain the search warrant. Once the search warrant is obtained, then they can go execute that search warrant, which means they can then go and actually do the search and seizure. If they don't have probable cause, or they obtain information from an illegal search and seizure, then that evidence is thrown out under the exclusionary rule because they did not follow what the Fourth Amendment laid out. This precedent was set by a Supreme Court case known as Mapp v. Ohio, and it's basically stating that evidence obtained without a warrant and not covered under one of the exceptions is not admissible into court. All right, let's talk about the Fifth Amendment. We're halfway there. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject to the same offense to be twice put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's a lot again, so let's break this down. Your Fifth Amendment addresses civil liberties of persons accused of crimes. So they have the right to be indicted by a grand jury on a felony case. So whenever you have a felony case, the district attorney or someone from that office will first present their evidence to what's called a grand jury. And that is a jury of that person's peers. It is not in front of a judge or anything. It's the district attorney calls this grand jury to say, we think we have enough to charge or indict this person. You tell me after I lay out all this evidence, do I? That is set up under the Fifth Amendment and is a protection. The next part of the Fifth Amendment is the protection against double jeopardy. And I'm going to highlight that. Double jeopardy. That is not a bonus round on the game show. Double jeopardy means that you can't be repeatedly prosecuted for the same crime. If someone has been convicted of a crime, they cannot be reconvicted of the same crime. This does not prevent a subsequent civil trial for the same conduct. But if Bobby was convicted of murder and he cannot be re-prosecuted for that same crime. The Fifth Amendment also protects against self-incrimination, which extending to persons in custody of police without being read their custodial rights, known as the Miranda rights. So this is very important. The Fifth Amendment did not establish the Miranda rights. Miranda v. Arizona established Miranda rights, which basically says that you have to be read your rights before, and you have to be read your rights and agree to speak to continue. However, the Fifth Amendment does protect the right against self-incrimination. And then finally, you have the right to due process. Again, I love due process. Remember, it goes back to life, liberty, and property, and due process guarantees fair treatment when the government seeks to deprive an individual of their liberties. The Fifth Amendment also prohibits the government's taking of an individual's property, which is known as eminent domain, without just compensation, but both have been frequent tools of the government and law enforcement, leading to property loss for many. So, if the government came and took my house, they would have to compensate me for my house. They could not just come and take it and not give me anything. All right, let's move on to the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and the district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusations, to be confronted by witnesses against him, and have compulsory processes for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So again, a lot of words, a lot of things kind of packed in here, so let's look at them. So basically, the Sixth Amendment addresses protections of an individual at trial. Those protections are and include the right to a speedy trial, so they're not left out there for 10 years waiting on the trial to happen. They have a right to a speedy trial, to a public trial, an impartial jury, a jury from the state where the alleged offense occurred, the right to receive notice of the accusations, they can confront witnesses, the right to compel witnesses to testify, and the right to assistance of counsel. So public offenders represent many persons during criminal prosecution if they're unable to pay for a defense, but they have the right to that. So it's important to kind of take a pause with the Sixth Amendment and look at what we call plea deals. So while a person has the right to these guarantees under the Sixth Amendment for trials, many who are accused of a crime and charged of a crime never make it to trial because they go into what is called a plea deal. And in a plea deal, That is an agreement between the defendant and the prosecutor where defendants plead guilty in exchange for a set incarceration period. So if Johnny is charged with voluntary manslaughter, no, let's say murder. If Johnny is charged with murder and the prosecutor comes to him and says, look, let's enter a plea deal. You plead guilty to the lesser charge of voluntary manslaughter. You go to prison for 5 years instead of going through with a trial and having the greater charge of murder and possibly facing the death penalty. Johnny's probably going to take the plea deal, but in exchange, Johnny has to plead that, yes, I did do this. So plea deals are double-edged swords. There are, in the criminal justice realm and in the law realm, there are some hesitancies around plea deals because of prosecutor workload and inequality with plea deals and things like that. But just know that plea deals happen, and a lot of people don't ever really get to trial because they choose to do a plea deal instead of going to trial. If you've never seen a courtroom, congratulations. This is what a typical courtroom looks like in the United States. Let me get my pointer. You have a judge who typically sits at the head of the courtroom. You have a defense table, a prosecution table, and then you have jury box. You'll normally have a side section with a chair where witnesses are called to, and then you have the public who is able to see public trials. Just a cool little example I wanted to include in there. All right, so let's look at the 7th and 8th Amendments. So the 7th Amendment states, in suits at common law where the value in controversies shall exceed $20, and the right of trial by jury shall be preserved, and no fact tried by the jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Basically, this amendment says that individuals have the right to engage in civil litigation. Sorry, that's hard for me to say. So that's not necessarily a criminal trial, but typically when you are doing civil litigation, you're wanting compensation or something like that. You sue people, things like that. The 8th Amendment is the bail amendment. So excessive bail shall not be required or excessive fines imposed, nor cruel or unusual punishment be inflicted. So when we talk about bail, we are talking about, let me get my pointer. We're talking about bail. We're talking about the payment of money that allows accused to be free pending trial. So if you get arrested for drunk driving, you go to jail. You can receive what's called a bail to get out of jail waiting for the trial to happen. You have to typically pay something. So like you put up 20% and a bondsman will put up the other 90 or 80%. So in the criminal justice realm, it is extremely rare for a bond to be deemed excessive. So right here it says nor excessive fines imposed. It's been extremely rare for the Supreme Court to find that excessive fines have been imposed. The 8th Amendment is highly contested in the criminal justice realm, especially in terms of bond. There's a big movement to do away with cash bail programs, which means like you get a bondsman, they pay some bond, you pay some bond to get you out, because there are inequities and the cash bail program is said to further exploit lower socioeconomic class. So just interesting to know. In terms of cruel and unusual punishment, there is a prohibition against cruel and unusual punishment. And think of it like torture, burning somebody alive at the stake. Some state Supreme Courts have found that firing squads violate the Eighth Amendment and are considered cruel and unusual. The death penalty overall has been said to not violate the Eighth Amendment. However, there have been nationwide bans on the death penalty for anyone with an intellectual disability or offenders who were under 18 at the time of the crime, or where there was a victim who did not die. Then you cannot get the death penalty. All right, moving right along. Let's look at the Ninth Amendment. Remember, the Ninth Amendment is where we start seeing those residual powers and state powers being articulated. So the Ninth Amendment starts, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. There are different interpretations of the Ninth Amendment. Some interpret the Ninth Amendment to protect certain natural or common law rights not enshrined in the Constitution. Other judges and scholars view the amendment as merely a tool of constitutional interpretation. And finally, let's talk about the 10th Amendment. The 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So basically, this is saying if the Constitution did not delegate powers specifically to the United States federal system and did not prohibit the state from having that power, the state has the power. So this solely focuses on power, and it says states are delegated powers not allocated to the federal government, and it allows states to allocate rights and liberties more fully or extensively than the federal government can. We're almost making it through. Like I said, this lecture is a longer lecture just because we have a lot of material. I would probably cover this in 2 weeks worth of face-to-face class period. All right, so let's move on and talk about privacy. So we've talked about freedom of speech, freedom to bear arms. We've talked about the government can't take over your houses. We've talked about search and seizures and protections for trials and crime. But notice that nowhere have we talked about privacy. The term privacy is nowhere in the Constitution, and it is the same for Georgia. The term privacy or right to privacy is not covered in our federal Constitution or Georgia's Constitution. So the right to privacy is thought universally to mean that it's the right to be free of government intrusion into our personal life, particularly within the bounds of our home. Some states do have privacy written into their state constitutions. Like I said, Georgia does not. There are 2 categories of privacy that we're going to talk about, and I need you to pay attention to this and take notes on this, because some of this information is not covered in your reading material. And you will want to remember some of this. So when we talk about right to privacy, think about Roe v. Wade, right to an abortion, or the Dodd's decision, which overturned Roe v. Wade. That's privacy. That's what we're talking about, privacy rights. Okay? So the first category of privacy is sexual privacy. Now, we're all adults here, and it's probably not what you think it means. So get your Snickers out of the way, and let's dive in. What do we mean by sexual privacy? Well, when we're talking about sexual privacy, we're talking about the right to contraception, the day after pill, birth control. We're talking about abortion, the woman's right to choose what happens to her body. We're talking about same-sex couples and the LGBTQ movement. That's what we're talking about when we're talking about sexual privacy. And our country has had a tumultuous relationship with sexual privacy rights for individuals. So these are all court cases. You can, if you haven't figured out by now, you can differentiate when I'm talking about a court case because all of the court cases will be in green. So let's start at the top with Griswold versus Connecticut in 1965. There used to be a law that stated that married couples could not get contraception, which is birth control. In Griswold, the court struck down that state law that forbade contraception. In 1972, the court further extended those rights to unmarried people. All right, so I need you to really hear me on that. In 1972, we're talking 70, 80, 90, 2000, about 50 years ago, 40, 45 years ago, it was illegal for unmarried people to get contraception in some states. It was not until 1972 that the Supreme Court gave those rights under Griswold. Then in 1973, we had Roe v. Wade. And I know Roe v. Wade has been a hot topic here recently with the Dobbs decision overturning the abortion rights and everything. But essentially, Roe v. Wade, the court ruled that the right to privacy encompasses a woman's right to have an abortion. Essentially, a woman had the right to choose what happened to her body. Then in the 90s, we had Planned Parenthood versus Casey. And the court upheld some state restrictions that required waiting periods for abortion. So in the 90s, you start seeing a more conservative movement toward limiting sexual privacy. Then in 2003, Lawrence v. Texas invalidated state laws that criminalize sodomy. Now, why is this important and why is this here? Sodomy laws were utilized to criminalize same-sex relationships. There were a lot of sodomy laws in the states that were utilized to essentially make same-sex relationships or same-sex sexual relationships illegal. It was in 2003 that the Supreme Court weighed in on that and invalidated those state laws. So up until 2003, it was illegal to have a same-sex sexual relationship in some states. And then Dobbs v. Jackson in 2022 upheld the 15-week abortion ban in Mississippi. It essentially overturned Roe v. Wade. And what the Dobbs decision said, if you read it, is it put the decision around abortion back to the states to decide how they wanted their laws to be. So Roe v. Wade put a federal protection for abortion and a federal protection on sexual privacy. Dobbs undid that federal protection because just because the Supreme Court made the decision and it's now precedent, it was never enshrined in law. So Congress never passed a law and enshrined it. So therefore, the discussion now is how do we enshrine it in law to have a federal protection? You have to change the law, essentially. So right now, we do not have a federal law that protects abortions. We are now under the Dobbs decision, and that precedent where states now have the say so in their laws for abortion. All right, so you can see how we've come as far as sexual privacy. We've really, some people say we've gone backwards. Again, if you go back to the federalism discussion and even our constitutional discussions, you have this tug of war of power between the state and federal systems, and you can see 60s, 70s, we were all for sexual privacy and kind of enshrining federal protections, and then in the 90s and the 2000s and 2010s, which has been more conservative and more neo-Christian driven, you see that those sexual privacies typically decline. So our next privacy category is dealing with communication and property. So technology, we all know, is ever evolving. I still remember when cell phones were like little boxes. And it was cool because we had a car phone, which was this little bag that you carried around with a phone and you could put it in the car. Now we have computers at our fingertips with our phones. So with the ever-evolving technology, we can see that tracking and monitoring is becoming much easier in our society. A piece of this that was very important, of course, was 9/11. I was a freshman in high school when 9/11 happened, and some of you probably, well, most of you probably weren't born, but there's a stark difference between the world pre-9/11 and the world post-9/11. When 9/11 happened, you see people willing to give up civil liberties for protection, or what's masked as protection. The U.S. Patriot Act became legislation, and essentially the U.S. Patriot Act was supposed to be used to help track and monitor suspected terrorists, to help the intelligence community get a head start. However, as we have progressed over the last decade, we found that the U.S. Patriot Act is really a tracking and monitoring system for everyday Americans. It's used to prosecute ordinary citizens more than it's used to track terrorists. And it's really kind of scary when we hear Big Brother. That's kind of what the Patriot Act was. People gave up their civil liberties for thoughts of being better protected from terrorists. And then finally, we have Carpenter versus United States in 2018, which was a Supreme Court case that further enshrined the Fifth Amendment rights. You had, I'm sorry, the Fourth Amendment rights. Further enshrine the Fourth Amendment rights. So basically, in Carpenter versus United States, the court said that law enforcement still needed a search warrant to gather phone data locations as evidence. So it's very easy for when a crime happens or when a person goes missing, law enforcement could just tap into a phone location system and ping your phone. Well, the court said, no, you still need a search warrant in order to do that. So remember, our Fourth Amendment search and seizure still need that. Still need probable cause to do that. Which that is a good thing that the court erred on that. It will be interesting to see, further cases coming before the court in terms of how technology interplays with our privacy. Because essentially, I don't know about y'all, but I can be buying groceries at a grocery store, and then all of a sudden I look at Facebook and there's ads for a certain type of mashed potato that I buy, and I'm like, how did you find that? I just bought that. So it's technology is a scary thing, but remember, privacy is not enshrined in the Constitution. So one form of technology that has made it easier to potentially monitor people's movements is is electronic toll collections, like the Easy Pass. I think Atlanta has the Sunshine Pass or something like that. The Peach Pass. Sunshine Pass is Florida. But basically, think about that. Like, you're paying for this pass, but it really is tracking your every move. And is that something you're willing to give up your privacy rights for? Just something to think about. All right, we have gone through a ton of material. Please take the time, rewind, watch this lecture as many times as you need. Feel free to reach out to me if you have any questions. The PowerPoint, this particular PowerPoint, like I said, I modified the publisher's copies. You have the publisher's copies, so feel free to go through those. If you have any questions, feel free to reach out to me. And as always, good luck. Your discussion board initial post is due by Friday, and your quiz and the full discussion board responses are due by Sunday. So I hope you have a great week. Thank you.